welcome everybody. Really good turnout today. It's nice to see everybody. This is our February contentious clinic, and it is a bit of a change to our death to distribution series, which we've been running. Today we are talking about wills and blended families, and really excited because we've got a new person with us today, hosting from IDR Law, Catherine Ayres, one of our solicitors here. She'll be hosting today, and she's been with us for about a year now, I think. Is it, Catherine?
Yeah, that's right.
Been with IDR for a year, and she's got extensive experience with litigation. She previously did commercial litigation and has moved into contentious probate with IDR. So thanks, Catherine, for coming along and presenting for us today. Really looking forward to it. And Catherine is joined by partner of IDR Law and
Yes.
chair of the Law Society Wills and Equity Committee, Stephen Lawson. So without further ado, I shall hand over to Catherine, and I'm sure if you've got any questions during the webinar, please do add them to the chat, and I'm sure they'll have some contact details at the end for you to contact them directly. Enjoy.
Hey, so welcome to IDRN with me, Catherine Ayres.
And me, Stephen Lawson.
So welcome everybody. Thank you very much for joining us today. We're going to do things a little bit differently today. We're not going to have a PowerPoint presentation on the screen. It's just going to be a bit more of an informal chat with me and Stephen. So our faces are going to be on the screen the whole time, so hopefully that won't be too off-putting for everyone. But we do have some notes which we can send afterwards if anyone would like them. So as the title suggests, we're here to talk to you about step families and blended families and potential problems for the will preparer. We seem to get a lot of claims arising from wills which relate to blended and step families, don't we, Stephen?
Yeah, it's not surprising, really, given the complexities of the issues arising. And as litigators, of course, we see things when they go wrong. So perhaps our view is slightly biased because the majority of cases, I'm sure, go through that are not contested or contentious, but all our work by definition is. So we see lots of things that go wrong, and we wanted to highlight some of the issues that we see so that you can help your clients when you're actually preparing wills. And I think we need to start with three preliminary points. The first thing, to state the obvious, but we need to state the obvious, is that in this day and age, all families are different, and some partners are married, some cohabit. And so the difference with a blended family may, to a degree, depend upon whether the parties are married or cohabiting. The other point, the assets in a family vary enormously because in some circumstances, the biggest single asset might be the family home, but in other circumstances, the biggest single asset may be other assets, a share portfolio, assets or interest in a business, shares, pensions, and all the rest of it. So what we're trying to say is, I suppose, it's a recognition that there isn't one size fits all. And by definition, as we go through, we'll be having to make some assumptions whether people are married or cohabiting. The other thing is that, and this is point two, that everybody likes fairness. Oh, we want something to be fair. But when you scratch beneath the surface, what is fair to one person might not be fair to another person. And for example, whether you are looking at fair to a spouse or partner, or whether you want to be, inverted commas, fair, close inverted commas, to the children. And there's often a difficult balancing act. And then the third and final point from me is that you've got to, of course, consider the assets that we're dealing with. I've sort of alluded to that already, because in this day and age, there are often lots of assets that are outside the estate, a lump sum pension, death in service, jointly held property, assets given away during lifetime, or trusts or whatever. So again, will preparers have to be particularly careful, and I know they are, with those preliminary points, that you've got to know what assets are going to be covered by any testamentary disposition.
Right, yes. So today we're going to be looking at some of the options available when making a will. So we're going to talk briefly about intestacy, mirror wills, mutual wills, and trusts of some sort. But before we get started, what is a blended family?
Oh my goodness. I hate saying this phrase, the Office for National Statistics, or the ONS. Well, they produce statistics in relation to the number and type of families and households. And I'll talk about that because they get that information from the census. But the easiest figure probably to remember is one that was produced by STEP in their STEP journal in February 2024. One third of UK families are now what you would call a blended or step family. So it affects a considerable number of people, and the demands might be different when you've got a blended family to when you've got a traditional nuclear type family. So the 2021 census shows that we're 700,000 step families, and there were 1.1 million dependent children living in step families. So it's self-apparent that private client advisors will be seeing step families. But the ONS definition of a blended family, it's not actually what you might think it is, just in terms of stepchildren. A blended family is what they say. There's their own definition. It's a step family which contains a couple and at least 2 children, and at least one child in the family must have a parental relationship with both members of the couple, and the other child being a stepchild. So the definition of a blended family, as I say, is different to a step family because a blended family technically means that the couple have got a child between themselves. And we'll see a case like that referred to a little bit later on in this presentation where things went quite dramatically wrong.
Okay, so step families then are families of any size containing one or more step parent or step sibling relationships. Of course, step families might not live in the same household because the children may be adult, but the legal issues and potential problems are essentially the same. So if we look at the options available then, the first one that I mentioned was intestacy. So that is where there is no will. So this is the do nothing option for a client, really. The obvious advantages is that it's little or no cost. It's easy for the client. They don't have to do anything. But obviously there are some disadvantages on intestacy. The rules of intestacy are inflexible, so they may not suit the needs of every client. And obviously stepchildren do not benefit under the rules of intestacy. So if a client wants the stepchildren to benefit, they're going to have to make a will.
Sorry, jump in and just say that of course is one of the issues that we get. Sorry, Catherine, to do that.
No, you're right.
That leads to Inheritance Act claims, doesn't it? If you've got children of the family, that's one of the touch points where on intestacy or otherwise, that leads to cases coming through our door. Sorry, I jumped in there.
That's okay. Also, another disadvantage is that the survivor in the couple might make a will after the death of the first to die, diverting assets somewhere that the deceased did not wish them to go, i.e. away from their own children.
Well, the other option, which was I might call the traditional option, is mirror wills, which tended to be identical wills, save for the name of the testator. And the tradition is all to surviving spouse or partner and then to children. And that tended to work well for the blended family. It's got the advantages that it's easy to understand, but it does involve trust between people. It reflects as well the age of the parties, because if you've got will preparers who are going to make wills for people, right, take a step back. I could never do the private client advisor job because it must be so difficult, right? You've got a loving couple who are there, they're coming to see you and they've sort of swallowed and thought, right, we better think about making a will. It must be really difficult to say to them, well, actually, one of you is going to die first, so what are we going to do? And then the next line is, and this is to a couple who are in love, well, of course, one of you is going to cohabit or remarry as soon as the other one's dead. You wouldn't do it as unsubtly as that. But that's the difficulty. You have to be able to explain to people. And of course, statistically, the younger a couple are, then the more likely it is that they will go on to form another relationship. So there's a degree of understanding there about how to deal with things. And again, it goes back to our one size does not fit all. But mirror wills are relatively straightforward. As we say, they're easy for people to understand, but already it leads into one of the problems, because what represents a fair distribution? So if you've got a couple that come in and it's a subsequent relationship, there are different understandings of what's fair. For example, we see cases where one party will say, well, I'm going to keep what I brought into the relationship and leave that to my kids, and you can bring in, you can leave to your child what you brought into the relationship. And some people think that's fair, and particularly people might think that's fair when they're the ones that are bringing in a massive contribution to the family. So, as we say, we're starting to scratch beneath the surface of what is fair and means different things to different people. But of course, there's another option. Well, if each party's got one child each from a previous relationship, then they might decide, well, we'll leave money equally between them, 50-50. But that becomes much more complicated, because just suppose if one party has 3 children by a previous relationship, and they might be infant children, and the other party has 1. So how is the estate then to be divided? Because it could be 50% effectively to my children, my 3 children, and 50% to my partner's 1 child, or you could do 25% each. Now, that also is a touch point on fairness, because we see that even at the will stage, people fall out considerably between themselves when they have to start addressing these difficult issues for people. So that's another touch point when that might have happened. For example, somebody's done a will leaving 25% to each, but one of them says, oh, well, I should have had 50% of my mum's share, particularly because mum brought in a lot to the family resources. So what are the other disadvantages, Catherine?
Yeah, I mean, I suppose after the death of the first spouse, like I said earlier with intestacy, then the survivor can freely make a new will, leaving perhaps everything just to their child, to the exclusion of the children of the first spouse to die, or even all children to the benefit of a subsequent spouse or partner. So this situation is probably one of the most common situations that we see at IDR law, and it can result in considerable distress, particularly as people can rely so heavily on inheritance. I mean, in one recent case, Waite and Skilton, Jason Waite, who's an adult child, has been charged with grievous bodily harm in respect of his mother's 86-year-old partner. I mean, this is an extreme example, but it just shows how upsetting it can be to be disinherited, particularly when it's not what was expected. It's not what was wanted or planned by the deceased. I've certainly had some recent cases where this exact thing has happened. The mirror will, a mirror will has been changed on the death of the first spouse to die, and everything has been left to the surviving spouse biological children. So the stepchildren have been left out entirely. And there's a real feeling of unfairness with this. And it's not just a financial aspect. Obviously people do rely heavily on inheritance, but it's the emotional side of things as well. It really just feels unfair, and really difficult to accept, for the people in that situation.
Yeah, Waite and Skilton, it was very recent. In fact, it was just a few days before last Christmas where this assault took place, all because of a will and the devolution of the estate. But it's important, I think, to focus on mirror wills a little bit, because they are common and they can work when there's a high degree of trust. But do you remember Linda Bellingham, Catherine?
Yes, yeah. I think she's an actress, isn't she?
Yeah, she's an actress,
Yeah.
and she was. You told me before that she was on Loose Women, but of course that's not my sort of genre. But I remember from when she was in the All Creatures Great and Small first series, but that probably gives away my age. But she'd been married 3 times, and she'd been given advice effectively that she'd get tax relief if she left everything her estate, because it was her taxable estate, to a third husband. but there was an expectation on the part of the children that that the husband would pass on her share to the children, and he didn't. So
Mm.
that resulted in a very public falling out because her children appeared on the GMTV couch with Philip Schofield
Yes,
bemoaning to the world the
mm.
problems with the third marriage and the fact that there was a mutual will, which did not lead to an expectation. But there's another case that I'd like to mention because it's a relatively recent case. It's called McLean and McLean, and it's a 2023 case which went to an appeal, and it involved Reginald and Maureen McLean, and it really, really is a tragic case, and it demonstrates, if anybody needs a story to show why mirror wills can go wrong, this is it, okay? Because Reginald had got 3 children by a previous marriage, and they had 1 child together. That was Brett. And this just shows you, right? They had been married. It was a second marriage for him. They had been married for 45 years. 45 years, okay? But he had 3 kids, and together they had 1. So the classic definition of a blended family. But they went to see a solicitor, a very experienced solicitor, who said, well, you can make mirror wills, and he explained what they were. And the solicitor said, well, of course, if one of you passes away, then the other one can make a new will. And it was said by Reginald in her presence and recorded in a file note, well, I trust her implicitly after 45 years. We want all our children to benefit. It went further than that because they wrote a note effectively to their all 4 of their children saying we want you both to benefit from our estate. Well, tragically, he died in 2017, and then within a matter of months, she had made a new will, leaving everything to the one son. She cut out the 3 children entirely, right? Absolute gross breach of trust. You can't have anything worse than that. So, the 3 children took legal proceedings, and they tried to say, well, you can't do that. They relied on 2 arguments. One was a mutual wills argument, and we'll come on to that in a minute. And the other was an estoppel claim because they said that the dad had relied on the promises, so that and those promises induced him to make a will, which it did. But the judge said the promises weren't sufficient and there wasn't enough reliance or detriment. So basically, the whole dispute was kicked out, and the one son, Brett, inherited the entire estate, which was certainly not the wishes of Mr. McLean. And it happened all within, as I say, a couple of months. So if anybody ever needs a classic case of where things can go so dramatically wrong, and it illustrates the reasons really why we wanted to do this talk and bring you this talk, because if you've not seen McLean and McLean, well, that's it, 2013. So sort of is the issue of mutual wills, Catherine, is that going to sort of solve the problem?
Yeah, well, I mean, yeah, potentially. I mean, what is a mutual will? It's an agreed mutual will that cannot be revoked after the death of the first spouse. So this has an obvious advantage over mirror wills. In principle, a mutual will sounds like a great idea since both spouses can agree to leave their estate to the other and then say to their mutual children. So this gives certainty to the first to die to know that their own children will benefit. But there are considerable difficulties with mutual wills, aren't there?
Oh my goodness, yeah, it's quite astonishing, really. And we've got quite a few cases on mutual wills. And I go around lecturing, as you know, sometimes in person. I have to say, I like doing the lecturing in person because you can get feedback and you can engage much more with the delegates who are listening to you. And what I find is it's quite funny, really, that some members of the profession will never, never, never go anywhere near a mutual will. And yet you get pockets of people who seem to do mutual wills. Sometimes they're will preparers, sometimes they're solicitors. I don't know, maybe just somebody gets a bee in a bonnet, let's do a mutual will. And I was told about one firm that always recommended mutual wills, but there are substantial, I mean substantial, complexities with them, because firstly, by nature, if it's binding, that means that the survivor cannot vary that will. And so on the one hand, that's the precise reason for doing it, that you've got certainty. But that certainty is also the downfall, because just supposing somebody has got a mutual will and they're aged 40, well, their circumstances are going to change hugely during the rest of their long life. They might live to 90. So for 50 years, you're stuck with a will, potentially, that you signed when you were 40 years old. And that leads to all sorts of other problems that we've sort of already alluded to. What if the survivor then gets married? That would revoke automatically at the moment the previous will, the mutual will. So the mutual will's revoked. That wouldn't be admitted to probate. It would be an intestacy unless they made a new will. But there's what you call a constructive trust over the assets, right? So that leads to two problems. Firstly, if somebody's married, can their spouse make a claim for reasonable provision under the Inheritance Act? Because by definition, if they've made a mutual will when they were 40 and then they get remarried, the house might be subject to the trust because it's used with trust assets. And then technically the survivor of the second to die would be kicked out the day their spouse died, and they wouldn't have power. Probably, I say probably, because the law's always a little bit unclear. I had one of these. I was desperate to take it as a test case, but it settled. But anyway, everybody probably knows the Law Commission are going to produce their report in April, and the issue of mutual wills is one of the many issues that they will be considering. The other problem with it is what happens to the assets. If you and I, Catherine, have got mutual wills and I die and you survive, to what extent can you spend our mutual money to the detriment of where you and I had agreed our money would, our joint money would go? Or can you do a remortgage on a property that you own, for example, and then spend the money on the high life? Or can you do an equity release on the property? Or what if you want to give some money away? Now, there are cases which say, well, you probably can't give it away because that's destroying the point of the mutual will. But as I say, supposing you have the high life on, so I'm no longer here to restrain your spending, how can you do that? And can the beneficiaries challenge it? So they're the sort of the messes that people can get into. And we've got some quite current cases on this. So if people have problems with mutual wills, then we've got a lot of expertise at the moment. But to summarize it on mutual wills, both the Law Commission in their report that I've referred to, their 2017 report, said that they would not recommend people enter into a mutual will. And the Law Society, if you've read their Wills and Inheritance Quality Scheme, they say that a mutual will should be entered into effectively only as a last resort. And there's a will preparer's obligation to explain every other option before recommending or allowing somebody to enter into a mutual will, and that advice has to be confirmed in writing. So there's quite heavy professional obligations on will preparers if you're going to go down that route, and that's another issue that people can get in a mess, because I know that clients come to us and they say they didn't understand really what the consequence of a mutual will was. And that was reflected by the Law Commission, who said members of the public don't understand the difference between a mutual will and a mirror will. So if you're going down that route, because Catherine said, and I agree, it's got potential advantages, but you've just got to be extremely careful with it. So perhaps one of the more common scenarios might be a life interest trust of some sort, where particularly if you've got a property as tenants in common, say 50-50, but it could be a 60-40 share. I could leave, if I wanted, my share to my kids, if that was the route I wanted to go down, subject to a life interest for my partner or wife to live in for life, and that might be one way of protecting a potential inheritance. So, what are the advantages there, Catherine?
Yeah, well, I mean, it's similar. You can control who owns your property even after death. So, as you said, you can let your spouse live in the property for life, and then your 50% or 60% or whatever you own goes to the children when the spouse dies. I mean, this is good if the biggest asset is a house. Does it combine flexibility with certainty? It does provide certainty as to what happens with the property, but then there are disadvantages with this option as well.
Yeah, I think that goes back to exactly what we said right at the beginning. If the house is the biggest asset, then fine. But how are you going to protect that? I mean, you can protect it, but how is it going to be protected if there are lots of other assets, perhaps assets in joint names as well? So that again throws additional burdens on the will preparer to go through all of that so people know what exactly is or is not going to be covered by a trust. And of course, it's more complex than a mirror will because by definition it involves a trust, and we see lots of people that come to us that don't understand or say they don't understand. Perhaps that's a very significant difference. They don't understand what a trust involves. And that leads to, again, another sort of touch point with potential claims against the estate for reasonable provision under the Inheritance Provision for Family Independence Act of 1975. That was what happened in a case called Cowan and Foreman in 2019 that went to the Court of Appeal. That, it has to be said, was a discretionary trust rather than a fixed trust. But the same principle would apply, because if I've left my half share of the house and the house is our biggest asset, and we've been married perhaps for a long time, my spouse might say, well, actually, just leaving me a half share isn't enough because I need more. I need greater flexibility. I haven't got a lot of income. I want to downsize. I want to use the income from the capital as not just the income derived from the capital, but the capital as well to contribute to my income because I need it to live. And that would be particularly important, perhaps, if somebody was going to go in a care home, if they were of advanced years, because they might say, well, the whole point of the trust is to protect the funds from a care home. But you can see the touch points, you can see the issues and the tensions that we talked about right at the beginning, the tensions between a spouse or partner and the tensions between children. The children as a global entity, not just my children as against my partner's children. And there is, of course, as well, administrative complexity with the trust registration service and potential income tax returns in relation to the trust. And that leads to another touch point that people come to us with, because if people haven't got the right trustees, that leads to disputes between executors or trustees and removal applications. I mean, I think that was one of the issues in the McLean and McLean case, because they'd originally tried to have a trust and appoint the mutual children as trustees and executors, but they sensibly realized that the kids would never work together. And so the solicitor appropriately gave them advice. Look, this is just not going to work. You know, if you're not here, this is likely to lead to World War III, which it did anyway. But from our point of view, it can sometimes, as I say, lead to court proceedings in terms of seeking directions from the court about the administration of the estate or trustee removal applications. Now, as we've alluded to, you've got two types of trusts essentially. I know there's other, but the main points are the life interest trust, which is fixed, but the discretionary trust, which gives flexibility with some circumstances. And the beauty of that, of course, is that it can take account of changes, and it can perhaps take account of provision for advancement to one of the children if they're in need, for example. But that relates to the point again we made right at the beginning. What's fairness? Is it fairness between spouse and children or whatever? So it's much more difficult. And I always like the word trust because it's got two meanings, creating a trust, but who do you trust? And probably the biggest single growth area in our work in recent years is disputes about executors and trustees, because that is often as a result of people not giving proper thought to the appointment of trustees, because or executors, because conflicts can be blatant, particularly if one person's living in a house who is also an executor and trustee, and there's an expectation that a house might be sold. It causes huge problems, which is why um, there's no perfect solution. But another option, of course, is lifetime gifts. And Catherine, I know you like this option, don't you?
Yeah, I may have mentioned lifetime gifts to my parents a few times, but yeah, they've just ignored me so far.
Well, if I see you turning up in the new car, then I'll know
Yeah.
your hints have struck home.
I wish, yeah.
But to go back to the beginning, right? It's about the assets. People sometimes think the main asset is the house, and that isn't always the case. But we see more and more, it didn't used to be the case, but more and more people, as wealth increases, people hold assets outside of a property. And so that's more difficult to control, of course, because it's a liquid asset. You can sell it, whereas a house might have somebody living in it. So life policies, pension policies, etc. And that also can have a huge impact, because sometimes we'll come across a case where provision has been made for assets covered by a will. Okay. And then sometimes trustees are canny. Sometimes trustees, if there's a dispute about the validity of the will, trustees might say, we're not going to make a decision until you've sorted out how the will is going to be divided if there's a will dispute. Okay. And then sometimes the trustees will say, well, here you are, here's all the money, and they'll pay it into the estate. But sometimes they'll just make a decision and pay it to beneficiaries. So you're effectively delegating the power over your assets to third parties who may or may not do what you want or hope for them. So that again is something to consider.
Right, so Stephen, what do we recommend then?
Oh God! Well, we've heard all that. This is where, if I was in a room, I think with delegates here, I'd be saying, "Well, come on, you tell us." All I can say is it all depends. It's it might be this, it might be that, but it's all about your clients, and this is where we keep looping back to what we said right at the beginning. Every family is different. Trust can work well. And I don't mean a trust, I mean trust between spouses and partners. But McLean and McLean, a 45-year marriage, to go so dramatically wrong after the death of the husband, poor Reginald, he must be, to use the phrase, turning his grave. Now, of course, it works for the majority of couples. We see a lot of disputes like this, but certainly the majority of families get on in perfect harmony, and they have any issues that they sort around a dinner table rather than a lawyer's table at a mediation or in court or whatever. So there's no doubt that mirror wills continue to attract huge popularity, and I can understand why, as long as clients are appropriately advised. Mutual wills were popular and are still popular with some people, but it tends to be against the sort of conservative, with a small c, conservative opinion, because there are too many risks with it. And certainly I would say from our experience here at IDR, is that mutual wills are more likely to provoke litigation than any of the other options. Mutual wills have the biggest risk factor associated with them, particularly if there's a long period. You know, if you've got a younger couple, or even somebody my age, you know, God knows I might live to be 100, you know, you never know. So the longer the period, the more likely a mutual will is likely to cause a problem. Lifetime trusts of some sort, a fixed lifetime trust, or even a discretionary trust, particularly perhaps if the estate is bigger, may be more appropriate options. But again, they are not without risk, as we've said, in relation to the case of Cowan and Foreman. So it's not easy, and it goes back to the balance of the identity of the trustees and the needs of the survivor, and whether they're going to be able to manage, or whether it is a Cowan and Foreman case. And care particularly needs to be taken in those circumstances about the identity of the executors. Now, what we're forever saying is this is what we do day in, day out. Maybe our view is tainted, but we are grateful to people who refer these issues to us. And our door is always open. We're happy to discuss issues and to deal with them further and give informal advice if people need that. From my point of view, I've talked enough, but I would like to say, if you're not registered with IDRN, and if you feel these things are useful, then please join the network. But from my point of view, I also do, through IDR, something called IDR Intel, where we do perhaps slightly shorter presentations supported by articles. Lindsay kindly recommended that, said that I was the chair of the Law Society Wills and Equity Committee, and that often gives us a lot of insight as to things that are coming, rather than, you know, this is what happened 6 months ago. So that's why we called it IDR Intel. So again, if you're not registered with IDR Intel, please do so. There's short videos. In fact, I think Catherine and I are doing one next week. I'm getting excited already. She knows I'm excited. We're doing one on the Law Commission, because the Law Commission are coming out in April, and I'll be speculating with insight as to what we can expect from it. So, as I say, I can hardly contain my excitement. If you want to see that with IDRN, then contact the team afterwards and they'll get you in.
Yep, that's right. Well, just like to say the same. Thanks very much for joining us. We hope we've been helpful. And yeah, just if you have any questions, just give me and Stephen a call or drop us an email. We'd love to continue talking about this. So thank you.
Lindsay, over to you.
Over here,
yeah,
Lindsay.
brilliant. Thank you both. That was lovely. It's a bit of a different clinic, wasn't it? Bit more one of your fireside chats, Stephen. Yeah.
Well, I don't. But do tell us. You know, if you're still there, if you're listening, tell us what you think. Would you rather have always PowerPoints on the slide? We like to mix it up a bit. We hope we could bounce it around a little bit for you. You know, it's easier if we're all in a room together, but we wanted to try that style. The slides will be available after this thing, so don't worry about not having slides, but please give us feedback. We're here to serve you, so let us know. Tell Lindsay that was great or that was rubbish. You know, we'll listen.
Yeah, definitely. Well, I loved it. Anyway, so yeah, just to say thank you so much, and we will be back in March for back to the Deft to Distribution season, I think. And then yeah, so please do join us for that. Another reminder, I know we absolutely battered you with IDRN spiel, but please do subscribe to the IDRN. It's completely free, and as Stephen said, get loads of that intel knowledge, and you also get all the resources for free, and you'll be able to download this webinar and all the previous webinars and anything that's coming up. So yeah, once again, thank you so much, and we will see you next time. Bye.